Today. My name is Jessie Peterson. I'm the Director of Education here at SunRay Construction Solutions. SunRay secures $10 billion annually for GCs, subs, and suppliers. We're a national construction document service. Today's webinar is conducted by the wonderful and incredible Alex Barthet, a Florida construction lien law expert. Today's webinar topic is how to get the bonding company to pay me. So without further ado, I'd like to introduce the fabulous Alex Barthet.
Thanks, Jesse. My name is Alex Barthet. I am a board-certified construction attorney here in Florida, and today we're going to talk about how to get a bonding company to pay you, and we're going to go through some very specific rules, tips, and tricks. So let's get started. So if you have any questions, you should have the GoToWebinar chat box somewhere on your screen. We will answer all the questions at the end. Please make sure not to include the names of any people or companies in your questions. All right, so what are we going to go over today? We're going to go over what are the bond deadlines, right? So we're going to go over the rules because you don't have any ability to make a claim unless you follow all of the specific rules. Then we're going to talk about what happens when you send the actual notice to the surety, like what is happening behind the scenes when they get your notice of non-payment. And then we'll talk about when will they pay you and how to get them to pay you. And of course, we'll answer any questions that you may have. All right, so let's go through these bond deadlines because they're very important. You need to understand the rules because if you don't follow these rules, then you have no chance of getting paid. So we're going to break this down into two types of projects. You either have a bond claim on a private job or you have a bond claim on a public job. So let's start with the private projects first. So if you have a contract with the bonded prime contractor, so for example, you're the electrician and you have a contract with the bonded contractor or the plumber or the roofer, you do not need to send a notice to owner, also known when you have a bonded job, a notice to contractor, but I recommend that you do. Again, it's not legally required, but it's best to have a process in your office where any job over a certain amount of money, $500, $2,500, $10,000, whatever you decide, any job with an amount over that threshold, you're just going to notice it automatically. Our most successful clients at collections have a rule, they stick to the rule, and they don't question the rule to determine, well, I actually don't need one here, so I'm not going to send it, but over here I do, so I will send it. That's where we see mistakes happen. So again, if you are a sub to a bonded contractor on a private project, you do not need to send that first notice, that notice to owner. Now, the next notice that you have to send is the notice of non-payment. That must be served and received by the contractor and the surety no later than 90 days from your last work or delivery of materials to the job site. That last work needs to be real work. It cannot be punch list work. It cannot be repair of your own work or warranty work. And 90 days is counted with every weekend and legal holiday in between. So if today is the last day I did work, tomorrow is day one. I count every day, including weekends and legal holidays. When I get to the 90th day, if it lands on a weekend or legal holiday, I roll it to the next business day. Now, the last step in this process is you have to file a lawsuit in court against the bonding company no later than 1 year from your last date of work or delivery of materials. Let me say that again because it's very important. The last step, under no circumstances can you wait beyond this date, 1 year from your last work or delivery of materials. Sometimes people think that they've made the quote unquote claim when they submit the notice of non-payment. That is true. That has to be done within 90 days of your last work, but the last step is to file a lawsuit within 1 year of your last work. So that means you have to hire a lawyer and they have to file a lawsuit. Do know that all of these dates are the outside most date. In almost every instance, you can do it sooner. So for example, you don't have to wait 90 days to serve your notice of non-payment. We're going to talk about why I don't think you should wait till the 90th day. And same with the 1 year. You don't have to wait a year. And we're going to talk about why I think you should do it much sooner than that. So that is the rule if you have a direct contract with the bonded contractor. But what if you are a supplier to a subcontractor or a subcontractor? Then the rule is slightly different. The rules are slightly different. So first, you do need to send that notice to owner or notice to contractor no later than 45 days from your first work or delivery of materials to the job site. That 45 days is the day it must be received in the mail. So you need to send it much sooner than that so that it gets there on time. The next rule is the same. You have to serve that notice of non-payment within 90 days of your last work or delivery of materials. And you have to file a lawsuit in court within 1 year from your last work on the job. Now, keep in mind, this is with respect to claims against the general contractor's payment bond. But if you are a subcontractor or a supplier to a subcontractor, there may be another bond at play which you don't know exists, but may be there, and that is the bond of the subcontractor. So let's take a specific example. You are a roofing supplier. You supply roofing materials to roofers. This job is a private bonded job. Your customer is the roofer, so they have the direct contract with the bonded contractor. You have a contract with the roofer, the subcontractor. So you are a supplier to the subcontractor on the job. The contractor may have a bond, and those are the rules we just talked about. But in addition to that, the roofer, in my example, may have their own payment and performance bond. Now, that bond of the roofer is not recorded in the public record. It doesn't exist anywhere for you to easily find it. So if you want to know if the party you contracted with has a bond, you need to make a specific request for a copy of that bond, one, to your customer, so in my example, the roofer, and two, you want to make a request in writing to the bonded contractor or the general contractor, whether they have a bond or not. And that contractor will almost always give you a copy of the subcontractor's bond if it does exist, because they would love it if you make a claim against the sub's bond and leave their bond out of it. And we're going to talk about how to make a claim on a sub bond in a minute. So we just talked about the rules for private jobs. Let's talk about the rules for public bonded projects. So if you have a contract with the bonded prime contractor, so for example, you're the electrician or the roofer or the glazing contractor with a direct contract with the bonded prime contractor, and again, we're talking about public jobs, so think a public hospital, public school, public courthouse, you do not need to send that first notice, that notice to owner. Again, for the same reasons I told you before, I think you should still have a process in your office to do that. You also do not need to serve a notice of non-payment. Let me say that again. If you are a sub to the bonded contractor on a public job, you do not need to serve that notice of non-payment. You still should, and you should have a process in your office to serve it, but if you don't, it is not legally required. So the only requirement to have a claim against a bond on a public job, if you are a subcontractor, is to file a lawsuit in court, hire a lawyer, file the lawsuit within 1 year of your last work or delivery of materials on the job. That is the only requirement. Now, that 1 year has the possibility of being extended beyond 1 year if all you are owed is contractual retainage. That's a little bit beyond the scope of today's webinar. So we're not going to get into all of those rules, but just know that you need to file that lawsuit within 1 year. But if you're owed exclusively retainage, there is a separate process. It's a little more intricate. Requires sending a letter to the contractor and the owner to ask certain questions and get a certain response. that may extend the time beyond the 1 year. If all you're owed is exclusively retainage, if that is the only amount of money that you're owed. So let's talk about what happens if you are a supplier to a sub or a sub-sub to a bonded, on a bonded public project. So in that instance, now all of the other rules apply. You need to serve that notice to owner / notice to contractor no later than 45 days from your first work or delivery of materials on the job. You need to serve the notice of non-payment within 90 days of your last work or delivery of materials. And you have to file a lawsuit in court within 1 year from your last work or delivery of materials. Again, if all you're owed is exclusively retainage, that 1 year has the possibility of being extended depending on certain triggers. And also remember, on a public bonded job, if you are a sub or a supplier to a sub, in addition to the contractor having a bond, the subcontractor may have a bond. Just know that if the job is bonded by both a GC's bond and a sub's bond, you have rights against both bonds jointly and severally, meaning they both owe you all of the money. You don't get it twice, but you have a claim against both of them, and whoever pays you first, that's great. So you can make a claim against both, and we're going to talk about how to do that in a minute. Now, I know all of these rules are a little complicated, so we have a tool, a desk tool that you can keep on your desk. It's called the Lien-O-Matic. If you don't have one already, we'll send you one for free. Go to lien-o-matic.com. It has all the rules that we just went through and more for public jobs, private jobs, bonded jobs, jobs that don't have bonds, Miller Act, which is federal jobs. The rules are slightly different there. And FDOT jobs, which again, the rules are similar but not identical for FDOT jobs. You can get this for free. Just go to lien-o-matic.com, fill in the form, and we will send you one within a few days. Okay, so you've sent your notice of non-payment to the surety. What's next? What happens behind the scenes? So your notice of non-payment just starts the process of the claim. So you, as the claimant, will typically receive within a few days of you sending that notice of non-payment a letter from the surety saying, please give us certain backup information and fill out this proof of claim form. So it has a list of questions they want answers to, and they want you to sign that document under oath and send it back to them. There is no legal obligation in the state of Florida to provide any of that backup information or that proof of claim. So you can provide it if you'd like, but it's not legally required. In most instances, we do not recommend to our clients to provide the backup or the proof of claim. Normally, it's because we do not see any real benefit at getting paid or getting paid sooner by providing the information, and I'll explain why in a moment. Now, there is one exception to this rule where you don't have to provide it, and that is if you are making a claim against a subcontractor's bond. So let's take my example again. You are the roofing supply house. You provide roofing materials to the roofer. On this job, whether it's public or private, it doesn't matter, the roofer has its own payment bond. You want to make a claim against that bond. So what have you done? You've submitted a request to the roofer and to the contractor, and you have said, please give me a copy of this subcontract bond, and they send it to you. What are you going to do? How do you make a claim on this subcontractor's bond? Again, we're not talking about the prime contractor, the GC's bond. We're not talking about that. We've already talked about what those rules are in the first part of this presentation. In order to make a claim on the subcontractor's bond, it is very simple. You get a copy of the bond, you read it, and you have to do whatever the bond says you have to do to make a claim. Payment bonds for subcontractors are not standard. There are some common bond forms like the AIA bond form, but it's not required. There's no mandatory subcontractor bond form. So everyone is different. So as a result, you need to get it, read it, and do whatever it says. So for example, the bond form, the AIA payment bond form, if that is the bond form that in my example the roofer has issued, then it typically says for you to make a claim on this bond, you need to provide a list of information. And it says what a claim, quote unquote, claim is, and where to send it to. And it lists a series of things that you have to provide. As long as you provide that information consistent with how the bond defines the process, then you have properly submitted the claim to the bonding company. Some bonds, and it's, it may feel a little uncomfortable, some bonds have no claim process, meaning you have a right against that bond, that subcontractor bond, even though you submit nothing. So you can submit something if you want or not. If you don't, if there's no requirement to submit anything to make a claim, the only thing you have to do is file a lawsuit against them. So typically what we see most clients do is at a minimum, they will send a notice of non-payment. So all the information that generally exists in a notice of non-payment, they will send that as their quote unquote claim, even if the bond doesn't have any specific claim requirement. So one of the things you have to understand is that most sureties will not pay you voluntarily unless the principal on the bond, so the GC who gets the bond or the sub who gets the bond for the job, agrees to pay you first. And the main reason is that suretyship is not insurance. When you get in a car accident and you have Geico or Progressive or Allstate as your auto insurance company, when the claim occurs, they come out, they adjust the claim, you go to a mechanic, they give you a quote, you work it out, you get a check, and you are not asked later to write the insurance company back a check for the amount of money that they just paid you. That would make no sense, right? But that is exactly how suretyship works, meaning if a surety company were to pay you your claim, they go back to the contractor who got the bond or the subcontractor and they say, hey, we just wrote a check for $100,000 to the roofing supply house. You need to write us, you contractor or subcontractor who got the bond, you need to pay us back the $100,000 we just paid to the bonding, to the roofing supply house. So it is a indemnity product. It is not a insurance product. So as a result, sureties do not like to pay claims and then chase their principals. They would much rather just have the principal on the bond pay the claim themselves. So we usually see this process of filling out a proof of claim form as just a way to keep you busy, not as a way to truly, in fact, determine if you're entitled to money and then write you a check quickly. They typically take whatever you send them, they pass it to the bond principal, the GC or the sub, and they say, hey, look what we got from this supplier or subcontractor. What do you want to do? So that's why we don't recommend necessarily filling out the information, and I'll explain what we do recommend to our clients on how to deal with it. Keep in mind that some sureties, as they get you to kind of go through this quote unquote claim process, they have the ability to shorten the time. I told you you have 1 year to file that lawsuit. That period of time can be shortened. How is it shortened? Well, you're going to get either a lawsuit filed against you or a letter sent to you via certified mail that can reduce that period from 1 year down to as little as 20 days. So be aware that if you get something that looks official because of the bond claim that you submitted, that you may need to act on it quickly. And also watch out for sureties effectively waiting you out. We had a client who submitted a bond claim, filled out the proof of claim, and every month or so would ping the surety adjuster and say, what's going on? And the surety adjuster would get back and say, we're investigating, we have a meeting, the contractor will get back to you, no, we're meeting with the owner. Fast forward 13 months after the claim was submitted, and the surety writes back and says, we finished adjusting the claim and we are denying it because it is now time barred. So they waited past the 1 year for the claimant to submit the lawsuit, right? I told you you had to file a lawsuit within 1 year. They waited past the 1 year and then they denied the claim. So do not get lulled into a sense of that anything is happening, that they're in fact investigating your claim, because they're just probably trying to wait you out, hoping that it goes past the 1 year. So what do we recommend our clients do? We recommend what I call the 60-60 rule. So the first 60 is at no later than 60 days from your last work or delivery of materials, that's when you should start the notice of non-payment process. Do not wait until the last minute to try to prepare all the paperwork and submit it. Remember, it's going to take some time to get the information, to prepare the document, sign it, notarize it, put it in the mail. And don't forget, the rule is it has to be received by the 90th day. So waiting to the last minute may cause you to have to send it via overnight mail. We've had clients call us the morning of the 90th day, and we've had to prepare the document and have a process server physically deliver it that same day to the bonding company, which was in another state, and the contractor, which was in another part of Florida. So keep in mind, we don't want to be running around at the last minute. So at day 60, that should give you plenty of time to get everything together and get that notice of non-payment out. Then for the next 60 days, hassle the customer and the surety. Send emails, make phone calls, send letters, be persistent at trying to collect the debt. The more you can do on your own to try to get paid and be the squeaky wheel, significantly increases your ability to get paid and reduces the need for the next step, which is if you are not paid within those roughly 60 days, you should submit your claim to a construction lawyer to file that lawsuit to get you paid. Unless you have a business reason to continue to wait. So for example, you submitted a $10,000 notice of non-payment on one job, a week ago, and you've got 4 other jobs with the same contractor. They're all going well. You don't want to mix, rock the boat with this relationship. You're willing to wait on this one claim while you continue working with this contractor on these other jobs. That's a perfectly acceptable reason to wait. But unless you have a reason why you don't want to pursue this claim, I do not recommend waiting much past 60 days from your own internal efforts to collect, to file that lawsuit. The sooner you file that lawsuit, much more likely is the sooner you're going to get paid. So with that, Jesse, do we have any questions?
We do have a couple of questions that came through, but thank you so much, Alex, for kind of going through it and shedding some light on some of these. There is a question, it's actually referencing, do these laws apply in California? It really depends on that state specifically of what laws are in place for that. Okay, so it says, what if we are the GC going after the subcontractor's bond? I think you kind of already went through it.
So again, I'm only licensed in Florida, so I'm going to assume this applies to Florida. If you are a GC going after a subcontractor's bond, typically that bond claim is against not the subcontractor's payment bond, but the subcontractor's performance bond, meaning the two bonds go together. The payment bond guarantees that bills will get paid. The performance bond guarantees that whoever gave that performance bond is going to deliver the project on time and on budget. Usually we see contractor claims against subs related to their performance bond. You can make a claim against the sub's payment bond as a GC if the sub has failed to pay their bills. The rule on that generally is you have to follow whatever the bond says is the claim process if you are going to make a claim against it for them breaching the bond. On a payment bond, that's usually just making a demand, sending a demand letter, and then suing the bond company for failing to pay those bills. On a performance bond, it's a little more complicated. You have to read that performance bond and make sure you follow all the steps in order to make a claim against the surety.
Okay, and I think this is part of the follow-up of that question that you just answered. It says if the subcontractor's work failed and after they perform the work, what is the time limit? Would that be what is specified on that particular bond, on the performance bond?
So if a GC is pursuing a sub against their performance bond, generally speaking, the time period to pursue that claim is either going to be listed in the bond, or in Florida, it's potentially up to 5 years from the issue that occurred that creates the default. That is the outside most possible date, but there may be sooner dates that apply to this specific example.
Okay, all right, thank you. Another question that came through, it says on a private bonded job, if I'm a sub and there's both a subcontractor's bond and a GC's bond, do I need to have two separate bond claims, or would I just include both bond numbers and all entities listed on the same notice of non-payment?
I would strongly recommend that you do two. Keep them separate because they are in fact separate bonds, and the rules that apply to each are separate. Remember, we talked about the very specific rules to make a claim against the prime contractor's bond, so you have to follow those. I would keep that totally separate from any claim that you may submit to the subs bond, remembering, of course, that a notice of non-payment to a sub bond may not be sufficient to constitute a claim, because you have to get that bond and you have to read it and you have to do what it says. Some of those sub bonds say that you have to provide a copy of this and a copy of that and these other pieces of information that may not be in a notice of non-payment. So again, if you're making a claim against a sub bond, you need to get that bond and you need to do what it says, whatever that may be.
Okay, another question that has come through, it says if a bond wasn't recorded, does that extend the deadline to file the claim?
Yes, if a GC on a project does not reference the bond in the notice of commencement, or on a public job does not record a copy of the bond, then the time frames to serve the notice to owner and the notice of non-payment are all extended until you have actual notice that that bond existed. So yes, you potentially have more time if that bond is not referenced in the notice of commencement or recorded in the public record.
Okay, perfect. I do think that is all the questions that have come through. If anyone does think of another question that we haven't addressed, please feel free to reach out and we'll be sure to answer any questions for you. All right, so here are some of SunRay's resources to help you stay organized, know your deadlines, and secure your lien rights. So please go ahead and check out that QR code. It will give you access to all of this, help you stay organized. Please remember each state has its own unique lien laws and bond claim rules and everything, so please check that out if you are working in another state. Next slide, please. All right, our next webinar with Alex is going to be Thursday, December 11th. That's, oh crap, I blew my lien deadline, now what? That's at 9 a.m. So please register for free at sunraynotice.com/education. We'd love to be able to see you guys there. All right, if you have a moment, please give us a review on Google. We really appreciate it, all your feedback. It really helps us always better ourselves and the content that we're putting out there for you of what types of webinars you're wanting to hear about and topics. And then the next slide. All right, and with that, that is all we have for you guys today. Thank you so much to everybody who attended. We hope to see you at our next webinar. Alex, as always, you really are incredible. Thank you so much. I hope you all have a beautiful and sunny day, and happy holidays, everyone. Thanks again. All right.
Bye, everybody.